You brought a lawsuit against two different doctors who treated you during the same hospital admission. You think that they both screwed up, causing you harm and injury. When I get a chance to question each of those doctors during their pretrial questioning known as a deposition, can I play one off against the other? Can I ask Doctor Number 1 what he thinks of the treatment rendered by Doctor Number 2? Can I ask Doctor Number 2 what he thinks of the treatment rendered by Doctor Number 1? You want to know the answer? Come join me for a walk through the neighborhood as I share with you the answers to those questions. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer is that in New York, no, I cannot do that. Why not? I'll tell you why. Because I am permitted to question a doctor during his pretrial question and answer session, known as a deposition, and I am allowed to ask him many questions. I can ask him what the standard of care was. I can ask him why he did what he did. I can ask him why he didn't do certain things. I can ask him his expert medical opinions. I can ask him hypothetical questions. Doctor, I want you to assume that Mrs. Jones came to you complaining of a lump in her breast. Would you agree in that instance it's critically important for you to take a detailed history about whether she has a family history of cancer? Yes, it would. Would it be important for you to go ahead and document that? Yes, it would. Would it then be important for you to go ahead and do a detailed physical examination of this patient? Yes. And that would include a thorough breast examination, correct? Yes. Including with the patient sitting up? Yes? Yes. As well as the patient lying down. Isn't that true? Yes. And if you found that there was in fact a breast lump, there's a very good likelihood that you would have referred this patient out to another doctor, correct? A breast specialist, a breast surgeon for evaluation. Isn't that correct? Yes. Doctor, I want you to assume that Mrs. Jones actually went to go see a breast surgeon on her own because she was concerned about the fact that her breast lump got bigger. The reality is that the defense lawyers who represent both Doctor Number 1 and Doctor Number 2 are never going to allow me to be able to get an answer to my question, even though I might be able to get the question out. They are going to make such a stink about the fact that I am not permitted to ask the doctor questions about whether or not Doctor Number 2 violated the basic standards of medical care, or whether Doctor Number 2's carelessness was a cause of my client's injuries. It's not going to happen. And there's specific law that allows them the opportunity to make those objections and to tell the doctor not to answer the question in that instance. There is really one exception, and one exception only. In New York, if both doctors are working together to treat the same patient for the similar complaints, it is possible, and in fact, we argue as the plaintiff's attorney, we argue that the doctors can and should be allowed to go ahead and comment on treatment rendered by Doctor Number 2 and hospital staff and Doctor Number 3, as long as they are all acting in concert together as a team. Now, those members of the team are allowed to comment on treatment rendered by the other members of that team. And what constitutes a team? Well, that's up for much legal debate. And I guarantee you that the defense lawyer is not willingly going to want to allow his client, the doctor whom you have sued, Doctor Number 1, to answer those questions. Because once he does that, now it pits Doctor Number 1 against Doctor Number 2, and their goal is to simply deny. We did nothing wrong, we did nothing wrong. Doctor Number 2 did nothing wrong, Doctor Number 3 did nothing wrong. And if they are successful doing that, guess what? Then you're going to be thrown out of court without a dime. Why? Because you will have been unable to establish that these doctors were careless and that their carelessness caused you harm and injury. I would love nothing more than to have Doctor Number 1 answer my question, was Doctor Number 2 careless? And you know what? I actually had the scenario come up. It was a very significant brain damaged baby case, a situation where a woman went into labor, and as a result of things that went wrong during the course of her labor, the doctor abandoned her. He had to go treat another patient, and the hospital failed to get somebody in to alert the doctor and to get somebody else in to take care of this patient during her labor when the baby's heart rate had dropped significantly. This young child suffered significant harm and injury. What was fascinating was that during this case, when I was questioning the doctor, the obstetrician, who was supposed to deliver this patient and who was watching her during the course of labor, the doctor turns to me in response to a question and said, you know, I feel victimized here too. I think that the hospital did something wrong here. And I did one of these double takes. I'm like, what? What did you say? Explain what you mean, doctor. And now this doctor proceeded to throw the nurse, the labor and delivery nurse, under the bus. He proceeded to say, listen, I was busy taking care of a very sick patient in labor. She was so sick she required my full attention for about 2 hours. And during that time, not a single nurse, not a single hospital staff came in to notify me that this patient, your client, was having a problem. Nobody came in to notify me that the fetal heart rate was dropping, that there were fetal decelerations, and they lasted for a significant period of time. Had I been told, I would have had somebody else take over what I was doing with my other sick patient and immediately come in and immediately done a C-section, an emergency crash C-section. But because the hospital failed to do what they were supposed to do, and even when I finally came in to take care of this patient and I realized she was having significant problems and the baby was in distress, they failed to have an available operating room for me to do an immediate C-section to get this baby out promptly. And because of that, this baby suffered the following injuries. And again, I did one of these double takes because in my entire career, I have never had a scenario, a situation, where the doctor, especially an obstetrician, turned around and pointed fingers directly at the nurses on the labor floor as well as at the hospital for failing to do what they should have done. In almost every other scenario, when I would go ahead and ask the doctor, Doctor, do you have an opinion with a reasonable degree of medical certainty whether the hospital delayed in going ahead and having an available labor room or an operating room for this patient for her C-section? Would you agree that that's a departure from the standard of care? In virtually every other instance, I would get an objection. Don't answer that question. That's totally improper, counselor. In this particular case, his attorney allowed him to throw the hospital under the bus because they were two separate entities. So he didn't care that he pointed fingers at the hospital. Now, here's something fascinating. When I had a chance to question this labor and delivery nurse, who he claimed was not doing what she was supposed to be doing, you know what she did? She turned around and said, that doctor is a piece of... Ugh. She pointed fingers right back at the doctor and said that doctor had the ability to watch the fetal heart rate monitoring, to fetal heart rate tracing in every single room on that labor floor. There was a monitor in the labor room. There was a monitor in the C-section room. There was a monitor in every patient's room. All the doctor had to do, no matter what he was doing, was to look up and to see. He would have seen that the fetal heart tracing had gone to crap, and now he should have done something about it. His failure to do that caused these problems, not anything that we as hospital staff did or didn't do. That was a remarkable, remarkable scenario where the doctor pointed fingers at the hospital staff pointed fingers at him, and I'm happy to say that as a result of everybody pointing fingers at everybody else, except my client, we were able to successfully settle that case. Why? Because there was no possible way that the defense was able to maintain a cohesive defense if they were to go to trial. Impossible. So let's go back to the question I raised at the beginning of this video. Can I get doctor number one to criticize the care by doctor number two or to criticize hospital staff? In almost every instance, the answer will be no. I will try, I will make an effort, and now I'll get into verbal disputes, verbal arguments with the attorney who represents these various doctors. And ultimately, in all likelihood, I'm not going to be able to get that information during the course of this pretrial deposition. So why do I share this great information with you? I share it with you just to open your eyes, to help you understand how these types of cases work in New York. And you're likely watching this video not because you wanted to see the nice scenery here, but rather because you likely have questions or concerns about your own matter. Well, if your matter happened in New York and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.